Today's webinar, The Essentials of Estate Planning and Elder Law, presented by Elville & Associates Managing Principal and Lead Attorney Stephen Elville. My name is Jeff Stauffer, Community Relations Director with Elville & Associates, and I'll be moderating today's event. So how this will work today, if you're new to our webinars, if you are, welcome. We're glad you're here. You as the attendee are in listen-only mode. However, you do have a voice today. When you have questions, please note them in the questions panel on the right-hand portion of your screen, and we'll take time throughout the presentation to address them. You did receive the presentation yesterday by email from me to take notes on it if you wish, but if for some reason you did not receive the presentation, it is available in the section marked handouts in the panel on your screen to download at this time. For CFPs, CPAs, and various other professionals on today's webinar, you may receive 1.5 continuing education hours for attending. So per attendance records requirements, please email me your ID number. And for CFPs only, I also must have the last 4 digits of your social security number as soon as possible so I can submit your CE hours for approval. Everyone will also receive a post-webinar feedback email right after the presentation. And we ask that you please take just a couple minutes to fill out the simple survey to offer us your valuable feedback about the presentation. It's also an ideal time to request a consultation with Steve for any planning needs that your family and you may have. And we always look forward to being a resource to you now and in the future here at Elville & Associates. So before we get started, I'd like to offer just a little bit of information about Steve and the firm. So hopefully you can see my screen. And Elville & Associates, we were founded in 2010 in Columbia by Managing Principal and Lead Attorney Stephen Elville. We do have a number of practice areas and services that we offer here at Elville & Associates, which include estate and special needs planning, elder law and elder care planning, estate and trust administration, business law and succession planning, guardianship and litigation, and tax planning and asset protection. We have 7 attorneys, 12 staff members in 5 locations, and our mission, as it always been and always will be, is to provide practical solutions to our clients' needs through counseling, education, and the use of superior legal technical knowledge. We do offer a lot of education here at Elville & Associates, and that is a big focus of ours here. We do that in a number of ways through our planning processes with our clients. We also offer over 100 educational webinars and workshops in the communities we serve each year. And we also do that by way of our accredited client care program. We're one of only 2 firms in Maryland to have a CCP, as we call it, accredited by the Client Care Academy in Boston. Has many robust benefits that many of our clients take advantage of. If you have questions or want to learn more, you can contact me and I'll be happy to talk to you about it or get in touch with our Client Care Program coordinator, Mary Gay Kramer, and she'll be happy to speak with you further about that. We also work with the ideals of client education, collaboration, and compassion with every client, every time here at Elville & Associates. A little bit about Steve. Steve's work as an attorney for the past 20+ years has been centered in elder law, special needs planning, and estate planning. He is a member of the National Academy of Elder Law Attorneys, the Academy of Special Needs Planners, and the National Network of Estate Planning Attorneys, and he works to bring peace of mind to clients by creating solutions, which is very important, to their needs through counseling, client education, and the use of leading-edge legal technical knowledge. Last year's chair of the Elder Law and Disability Rights Section Council of the Maryland Bar Association offers many webinars, workshops for businesses and their employees, conferences, and continuing education events each year, and also named to the Maryland Super Lawyers list for a 6th time in 2021, so congratulations to Steve. And he also had a featured story written about him in the National Super Lawyers magazine about the Elville Center for the Creative Arts, which is our firm's charitable organization he founded in 2014, and I am privileged to be the executive director of. So if you'd like to learn more about the Elville Center, please reach out to me or Steve, and we'll be more than happy to share our story about the Elville Center and how we work to make a difference in the lives of children every day throughout Central Maryland and beyond. So that is our story here at Elville & Associates. And we're going to start off with a brief poll To learn what's brought you to our webinar today, I'm going to go ahead and launch that. And the simple question is, what has brought you to today's estate planning and elder law webinar? And the responses, as I launch this poll, are: 1, these concepts are new to me and I need to start planning. 2, I have a plan in place that is outdated and needs updating. 3, I have a plan and I'm here to expand my knowledge. Or lastly, number 4, I'm an advisor here to learn to better serve my clients. So just take a few seconds to make the choice that best fits your situation. And the results are coming in. We'll give another 10 seconds or so, I'd say. Okay, so we have about 3/4 of the people who have cast their ballots. And with the results in, 7% say these concepts are new to me and I need to start planning. 26% say I have a plan in place that is outdated and needs updating, which is not out of the ordinary. 41% say I have a plan and I'm here to expand my knowledge. And 26% say I'm an advisor here to learn to better serve my clients, which is always great to hear. Welcome to our advisors and our clients and anybody that's new to Elville & Associates. So I'm going to close that out. I'm going to turn the reins over to Steve. I'm going to give you the presenter rights, Steve. You should see that button pop up.
All right, Jeff. Very good. And let's try that one more time, because I think what happened was I tried to get my presentation up, Jeff, and I might have clicked too soon. All right, there we go. Well, let me just say that I'm getting to where I need to be. There we go. So Jeff, let me ask you, do you see the presentation now?
I can, yes. So just go ahead.
Very good, thank you.
Start. Very good.
Very good. Good morning, everyone, and thank you for your patience there as we get situated. I'm Steve Elville. I'm the managing principal of Elville & Associates, and thank you for taking time out of your busy day today. It's a beautiful, beautiful June day. June is my favorite month of the year, for those who may know me, but here we are at June 30th already, and I know it's vacation time, it's summertime. We wish you all the safe travels and so forth, as I know many of you are getting out on the road and going away and enjoying yourselves this summer. And I want to thank Jeff, my friend and colleague, for helping put on these workshops. I could not do what I do without Jeff. He's awesome, and he's going to be here today to take questions from you as we stop occasionally throughout the workshop. So Jeff is here for you. He's a resource. Thank you, Jeff. And by the way, Jeff's getting ready to go on vacation himself, so I know he's anxiously awaiting that time with his family coming up. As I mentioned, we're going to be talking about questions and answers. Many of your questions help us in this presentation, so don't be afraid to ask, and don't be afraid to hit that button and ask Jeff to answer a question or to forward a question to me. This particular presentation is a compilation, I would say is the most comprehensive compilation of my experience, I guess, over the last 20 years. And I know it's a foundational presentation. This is very basic stuff, but it's very important stuff. So as we think about planning, whether we're doing new planning, whether we're updating old planning, we want to give you a path forward. There's no reason to be nervous. There's no reason to be confused about any of this. This is an educational process. Here at Elville & Associates, we give clients a room to think about these things. We bring up all the choices that are available to people in contemporary planning, how to update, how to look at the basics of estate planning, the basics of elder law, the basics of special needs planning, for example, and how to move forward. So we don't want to just educate, even though that's extremely important to us, and we've been doing that throughout our history. We really want to give you a path forward. So look at this information as the foundational principles that will give you that feeling of peace as you start this process, that you know more probably than 90% of people out there about these concepts, just because you were looking at this material and taking in this material today. So with that said, I'm going to start and we're going to move forward. So what are our goals today in this presentation? Well, what is an estate plan? What is estate planning all about? And what is the process for planning? And there are different processes, or there are no processes. We're going to find that out. We certainly do want a process, but this is the first and foremost thing we're going to cover. We're also going to talk about something that's slightly negative on this beautiful day, which is, why do estate plans fail? And how can you avoid that? We have to recognize that many estate plans don't work the way they're supposed to. How can we avoid that? One of the most fundamental questions people ask across the nation: what are wills versus trusts? What are these concepts? Basically, those are probate and non-probate concepts. How do I think about those things? Then we're going to talk a little bit about elder law, the basics of elder law, taxation, what's going on in the world today in taxation. Asset protection planning is very important to people. We're going to talk about that. And we're also going to, again, give you a way to get started. How do you think about taking the next steps? But again, we're here today to educate, to facilitate, and to really be a resource for you. So why do we plan? Well, I say this all the time. I was saying this to an advisor yesterday I was talking to, and I say this to all clients, whether it's elder law or estate planning. Planning is all goal driven. You have to have a goal, which is our next slide actually, but you need to understand what your goal is. Your goal could be very simple, but you need to have a why. And this is not only true of planning, of course, this is true in many aspects of life. But we have to recognize that some plans do fail. Many plans fail because of various factors: lack of education, lack of a process. We're going to talk about that. So again, I want you to have a purpose in mind. If you don't have one today, or it's ambiguous to you, I want you to be thinking about that. I want you to have a goal, and I want you to remember, as you think through estate planning concepts, if you keep your goal in mind, this will help you. It will make it less stressful. It will make it more purposeful. So again, I'm just going to give you some basics here. Why do we plan? Well, many people want to provide certainty where there is uncertainty. We certainly have that in the world today. We want to facilitate smooth administration. Many people want to have the smoothest administration possible. For what purpose? Not only to minimize stress on family members, but to minimize the cost of administration. So can we minimize the cost of administration through good planning up front? And the answer is yes. Some people are focused on asset protection. How do I protect for Medicaid purposes? How do I protect spouses? How do I protect against remarriage and the assets going to a new spouse? How do I protect children and grandchildren? How do I minimize taxes? How do I eliminate taxes? How do I achieve my special purpose? Maybe it's a foundation you want to establish. Maybe you have a special needs loved one. Whatever it may be, that is very, very personal to you. And what we don't want is, we don't want your planning to be just like 1,000 or 100,000 other plans that look all the same. We don't want that. So why do plans fail? Well, there's a variety of reasons. Mostly it is a two-way street where we have to put blame on both sides of the street. One street is where the clients are. One street is where the attorneys are. And there has to be a partnership between clients and attorneys. If there is no partnership, if there's no connection really between the client and the attorney, then the plan can fail. And I'll give you an example of that. Most people don't most people don't update their planning for 19 years at a time. That means that, first of all, most people don't have any plan at all. For example, probably 55 to 60% of people in this country have no plan. But even those that do have a plan, they don't update them regularly. Although I have been impressed recently with people that are coming in more frequently, or people that are members of our client care program that Jeff talked about that encourages updating. The average person either doesn't have a plan at all, or the average person that does have a plan only follows up every 19 years. Now let's think about that. Look at what's just happened in the last 16 or 18 months, let alone what could happen in a 20-year period. Is it possible that a plan could fall out of favor? It could fall out of alignment with the tax laws. It becomes obsolete as to certain provisions. And the answer, of course, is yes. So we don't want to treat our documents. When you do a plan and your attorney hands you a set of documents, we want to look at those documents not as the plan. We want to look at those documents as part of the plan. Documents themselves can be perfect, but the plan can still fail. The documents could be outdated, even though they were drafted perfectly. The documents could be driving assets in a certain way, theoretically, but actually the assets are titled in a different way. We're going to talk about this, that the assets have to be in alignment with the planning. And this could be devastating for tax purposes, special needs purposes, asset protection purposes. It could be devastating. So we want to follow up. We want to have a process to avoid planning failure. Now, this is an oversimplification, but I would classify planning in two different ways. One is the traditional method. This is the one I just described, where there is a focus on document creation. Documents are created, and documents are created in a variety of ways at law firms. The documents are translated over to the clients, and basically that's it. There's no education, there's no follow-up, or there can be a process-driven educational system. And we call that here at Elville & Associates our caring for clients model, or legacy process, whatever you would like to think of it as, but it's a process-driven educational program. We don't want this, what I call traditional estate planning approach, because it really has one phase. And that's what I just discussed. There's no updating, there's no education, and I think you understand this pretty basically. And as a result of that, you may never hear from the law firm again. You yourself may never be motivated to contact the law firm again, and there's no partnership, and that's what I talked about initially. So to avoid that, we want this process-driven, educational, fundamental type value-based approach. So this kind of process really incorporates education, maintenance and updating, and client care. So this is kind of continuing client education, continuing client involvement, continuing client updating based on changes in the laws, changes in the nation, changes in the political processes that can drive changes in the laws, tax-driven, or maybe we get away from that and maybe the plan is very personally driven due to new circumstances in the family. But these things are not left to chance. Beneficiary designation, something as very simple as a beneficiary designation, can make or break an estate plan. So these are the things that we have a first, second, third, fourth chance to make sure that those things are taken care of, because the plan is not just one phase, it is a life process. Let me give you a basic definition of estate planning, and you can write your own if you would like. What does estate planning mean to you? Well, estate planning in this particular simple example is being able to dispose of your property the way you want to the persons or organizations of your choice at the lowest possible cost. So let me give you that simple illustration or simple definition again. Estate planning is about disposing or leaving your property the way you want to the persons or organizations of your choice, for example, charitable giving, at the lowest possible cost. So that could be a definition that resonates with you, or you can take that basic definition and build on it as you think about your goal, as you think about your purpose. All right, Jeff, I'm going to stop. We've been going about 10 minutes. Do we have any questions so far? I know it's pretty early on.
No questions yet, Steve. I'm
All
sure they'll be
right,
coming in soon.
very good. So I'm just checking in. All right, so now let's get into one of the most fundamental things that is part of estate planning. If we were to ask 100 people, I guess, across the nation, chances are, if we ask them what is important to them about estate planning, many people will say, majority of people would probably say avoiding probate. But those people may or may not understand the nature of probate or what is wills, probate process versus trust, no probate process. Let's go through this. These are the fundamentals that many of you have questions about. I want you to know that this particular slide we're looking at now is a very, very concise summary of a probate process. So we're looking at a will here, and I'm going to go one slide in advance just to show you. This is a will-based plan. If you come in to do estate planning with a traditional estate planning firm or what I would say a progressive estate planning firm today, this is what you would see as a basic will plan. The will is the driving force of the plan. The powers of attorney, the ones on the left of your screen, those are for incapacity planning. We're going to talk about that. The advanced medical directive is for incapacity planning as well for your healthcare decisions. But for the driving force of your planning, it is the will. So a will, by its very nature, is subject to probate. By the way, if someone doesn't have a will, do we still have probate? Well, that's going to depend on what the assets are. So let's talk about what assets are subject to probate. Okay, and that's the third bullet point here. The assets that are subject to probate are basically assets that are not jointly owned with another person, so they don't pass by joint ownership. Assets that are solely owned by someone with no beneficiary or no joint owner. So in Maryland, if I own a rental property that's solely in my name, or I own a brokerage account or a savings account that's solely in my name, and I have no beneficiary, I have no joint owner, at my death, that asset is going to go through probate because I have no joint owner, no beneficiary. What is probate? The probate process is the process of proving a will to be valid. Is this will valid? Does everyone that's involved, meaning all the interested persons, have they been given notice? Have the creditors had a chance to make a claim? Hopefully there are no creditors. Has the accounting been done? Has there been an inventory? Is everything, have all taxes been paid? This is basically, in a nutshell, the probate process. The reason that it takes about 9 months for a regular estate is that is traditionally when the first and final, hopefully final, account is due in 9 months. So a will structure basically says this: if we have probate assets, those assets go through my will. My will is going to be subject to the probate process, which is a public oversight process. And by its very nature, that is going to take several months. The cost of probate is around 4 to 7%. This includes costs of advisors and attorneys and CPAs, or the personal representative's commissions. Remember, in some states, the personal representative is called the executor. So this is not actually something that we can nail down too much. In some states like California and New York, I understand the probate costs are even higher than about 4%. But if we take the statutorily allowed fees, I should say, and if we look at those closely, those equal about 4% of the probate assets. Now, what if we have retirement plan assets like IRAs and 401ks, and those assets have beneficiary designations? Do those go through probate? And the answer is no. But if we don't have a beneficiary designation, which is a very sad situation, then those retirement assets that would have not gone through probate now are part of probate. The same thing is true of life insurance policies. If they have no beneficiary, they will be subject to the probate process. So probate is something that can be avoided. So let's go to another structure, and this is the revocable living trust. So if we are looking at basic estate planning, wills versus trusts, we're really talking about a revocable living trust. Now, all this is a will substitute. So think of this as I can have a will or I can have a will substitute. The revocable living trust is not magical. Some of you on this call have a revocable living trust and maybe it needs to be updated. Maybe it needs to be properly funded, or maybe the funding needs to be reviewed. But basically, it's a private agreement, and it's designed, and by the way, you pay the tax, so the tax filing doesn't change. You always file your Form 1040. After you have a revocable trust, you continue to file your Form 1040. Nothing changes until your death. So what is a revocable trust? What does it not do? Well, a revocable trust does not save on asset for taxes, or does not provide asset protection, but it can avoid probate. So there are two steps with a revocable living trust. The first step is the creation of the trust, just like you would create a will. And this is what the structure looks like. We have a little bit of a different structure here. The revocable trust replaces that primary will, as you see, and it becomes the driving force of the plan. Once we have the revocable trust as the driving force, then we have a new type of will that backs up the trust, just in case, heaven forbid, you're one of the people who does not fund your revocable trust properly, and we still have probate. We need a backup will. Our goal is not to have probate if we're going to use a revocable living trust. But notice that we still have powers of attorney, we still have advanced medical directives. So the revocable trust avoids probate if the two steps are taken, which is one, developing the trust properly and signing it into existence. Two, funding and alignment of assets, non-retirement assets like savings, money markets, brokerage accounts, mutual funds, CDs, all of those types of things, including savings bonds, should be retitled in the name of the trust, while IRAs and qualified plans and life insurance generally stay outside of the trust. Retirement plans for sure stay outside the trust, because we cannot retitle a retirement plan inside of a revocable trust because it would trigger taxation. So just know that there is not a, well, this one is better and this one is worse. Everything is driven by your goals as a client, okay, or the client's goals, and that's going to be driven by, do I have a desire to basically get a solid basic plan in place? I'm not concerned about probate. I simply want to get my planning in place. There's nothing wrong with a will-based plan. Some people prefer to avoid probate, and they want to make things as smooth as possible for the administration and take the very likely hood into consideration that the cost of the administration is going to be much lower with a revocable trust, much lower overall if everything is properly done and maintained during life. So it doesn't matter which one of these you do, as long as we do it comprehensively and as long as we're following your goals. Now, there are three categories. I've talked to you about two categories of estate planning. I want to talk to you about three now, and then we're going to break for questions. We talked about wills as the first category, and by its very nature, the will is subject to probate. If we have no will, we still may have probate, depending on the type of assets. Over here on the right-hand side, I would say this is our far column, our far right-hand column. This is where we had the revocable living trust. The revocable living trust is a nice tool. It's a nice management tool. We do many of these. It's a counseling issue, but the revocable trust does not perform the way it's supposed to unless it is properly funded with assets. We just talked about that. But in the middle category, I like to say we have what we call non-probate transfers. And these are very, very familiar to you, most of them. So joint ownership, beneficiary designations, we'll come back to life estate deeds, transfers on death, TOD designations on brokerage accounts, for example, payable on death designations on bank accounts, or in some states, like some of the northern states, there can be something called an in trust for account, which is very similar in my experience to a POD account. A life estate is where someone can have a life estate, literally in real estate, in your residence. I want to have the right to live in my residence for my entire life, and no one can ever kick me out. But at my death, it passes to, let's say, my children, who are called the remaindermen. So life estates can be Medicaid planning tools, or they can simply be probate avoidance tools. So being familiar with all of these now, I want you to think in terms of wills, revocable trusts, and then this category in the middle, non-probate transfers. We get a lot of questions about these non-probate transfers. Here's my answer to most of them, and you may have some today. The reason the vast majority of people, I would say well over 95%, maybe more, maybe 98% of people use wills or revocable living trusts as part of their planning is because with wills or trusts, you can actually control how things go down. How do you leave assets to your spouse? How do you leave assets to your children and grandchildren? How do you achieve your goals? Well, you can only achieve those goals through control and having the ability to control how assets go down. If we use these non-probate devices or non-probate transfer devices, that can be very useful in certain planning techniques. But in and of itself, using these tools, even though they technically will avoid probate, every single one of them, they do lack the ability for you to control the ultimate outcome. This is if loved ones were to die in an order where you could not have anticipated. You could not have anticipated that, or someone has special needs that you could not have anticipated. They do not allow you to exercise ultimate control down the line of disposition, and it could result in you having the result that you were not looking for, or an undesirable result. So we talk about wills, revocable trusts, and using these non-probate devices mainly as tools in elder care planning and in other types of planning. So I wanted to get through that because that's one of the major features or major fundamentals of learning today, which is wills versus trust versus non-probate transfer devices, and how does that all fit together. As we work through just a couple more slides, let's talk about these non-probate devices and how they can be problematic. You may remember that early on in the presentation, I was talking about the need for partnership, the need for education, the need to look at documents as what they are. They're just documents. Documents themselves can be perfect, but look at this example. This could be the best will or trust in the world, as we're going to also see on the next slide. This was a fantastic document. It was truly modern and contemporary in every way. It was leading edge. But look at what happened. I intended that my will or trust control how the assets go down to my beneficiaries. But look at the way that I had everything titled. I had things titled by way of these non-probate transfers. So they simply went to the beneficiaries or the surviving joint owners or the surviving remainder men. And the intention that I had in my will or trust to control that, or to provide asset protection, or to protect against bad marriages, or to provide special needs planning, all of that could go down the drain here because, or would have gone down the drain because I left everything outright. This is a different way of looking at the same thing. I have passed away in this example. The person passes away. They leave assets in a certain way because the titling was not addressed. Remember, in a will plan or a trust plan, there are two steps. I previously said there were two steps in a revocable trust, which is very true. The implementation and then the funding and alignment of assets. What I should say now is my personal belief is that there are two steps to every estate plan, even if there's a will-based plan. With a will-based plan, we're not retitling assets. We are simply designating beneficiaries in addition to the will. But if we don't take that second step, if we don't beneficiary designate those assets properly, we will have a result we are not looking for, and most of the time. So here we've got the best will or trust in the world, but the way things are titled will defeat possibly what we have tried to accomplish in the documents. So the documents and the titling of the assets and how the assets flow have to be coordinated. And that's why I'm saying here funding is the key to estate and elder law planning, and also special needs planning. And the word funding is quite confusing. So I'm going to say the word funding is the equivalent of what we would call asset alignment. So aligning assets with the estate plan, coordinating the asset flow with the estate plan is the key and possibly and arguably the #1 thing in estate planning. My last comment before we go to questions, if any, is this. One could argue that how you own your assets at the time of your death, how those assets are titled, is arguably the most important thing in estate planning. All right, Jeff, I'm going to take a break here for 2 minutes and see if there's any questions.
Steve, no questions yet.
All right.
I know they'll be coming though.
We've got an educated group here, and it's so beautiful outside, it's probably hard to concentrate. All right. Now, on this beautiful day, I'm going to talk to you about something here on a Wednesday morning that's not easy to talk about, which is understanding incapacity planning. Now, we here at Elville and Associates are elder law attorneys, of course, and estate planning attorneys. We understand this, and we try to bring this to light. I was talking to a wonderful financial advisor yesterday on a webinar, and that he was putting on, and he brought this up, which really was near and dear to my heart, the importance of financial powers of attorney. So let's get into that. What we're trying to do with powers of attorney and advance directives is we are avoiding guardianship. So many of you who are younger and may have young children, I know you, and I know what you're concerned about. You're concerned about what happens if something happens to me and my spouse and my minor child needs a guardianship. Well, obviously that's the most important thing in planning to you as a young parent. But as we get older, we have to be concerned about guardianship of ourselves and avoiding that guardianship of an adult. What if I'm young or old, but I'm an adult and I'm over 18 years of age, and let's say that I am incapacitated. Something happened. Well, now, if I don't have a financial power of attorney or an advanced medical directive, I may be subject to guardianship of my property, guardianship of my person. Now, of course, all means should be exercised to avoid guardianship. Guardianship should be the last resort. So that's not automatically going to happen in many cases, but in some cases it will. So we want to understand the importance of incapacity planning. Incapacity planning is extremely important, as my friend said yesterday during the webinar, because most people don't realize that a financial power of attorney not only takes care of you if you become incapacitated, it takes care of anyone who is dependent on you. So the financial power of attorney is arguably the most important document in estate planning. So let's talk about guardianship. I'm going to give you 2 brief examples. I hope that this will resonate and that you'll learn from this. It's a story of woe that I will make believe never happens, or hopefully will never happen. But let's pretend that I drive home from my office today, and I live toward the Annapolis area. So let's say I'm driving there, and let's say that I do not have a financial power of attorney, which of course I do. But let's say that I did not have that in place. So I'm unfortunately injured in a car accident, God forbid, and I'm in a hospital. I'm married. My spouse comes to the hospital. My question to you to think about is this: can she make my financial decisions? I have no power of attorney. I am incapacitated. Can she make my financial decisions? I'm going to let you think about that for 10 seconds. Well, the answer is no. And unless my spouse is a joint owner with me on a piece of property or on a bank account, if I have accounts in my sole name, like a checking, savings, IRA, anything like that that's in my sole name, or if I had a rental property in my own name, she would not be able to make my financial decisions and control and deal with my property. So in that particular instance, she would have to petition for guardianship of my property. Let's say I was in that facility, I didn't get better anytime soon, I was transferred to a rehab center. Now I've lost my legal rights to my property because my spouse, even though I was married, my spouse has to petition for guardianship of my property. Now, on the other side of the fence, this is the healthcare side. my spouse comes to the hospital under those circumstances. Can she make my healthcare decisions if I have no advance medical directive? And if I've named no healthcare agent, I'm going to give you 10 seconds for that answer to think about it. Well, I know many of you are thinking exactly what I'm thinking, which is I'm trying to trick you a little bit. So thank you for playing along with me. In this circumstance, my spouse can make my healthcare decisions because of something called surrogate decision making. So Maryland has something called surrogate decision making, where my spouse, as a person at the top of the list of priority, can actually make decisions for me. So I wouldn't necessarily have a guardianship of my person, which would be terrible if I didn't have an advance directive. But fortunately, in my example, my spouse was available to act for me. What if my spouse or children were not available? What if they were injured in the same accident? I could be subject to guardianship of my person, which now I've lost all my legal rights, my rights to my person, where I live, my healthcare decisions, my rights to my property. So this is a very serious thing about your self-determination and your future liberty, really. So we want to make sure that we have agents under our powers of attorney and advance directives, and that we keep these powers of attorney up to date. In a perfect world, we would have at least 2 or 3 agents for each one of these and constantly keep these updated over the years so that we are eliminating the need for guardianship. Now you'll notice, as I go backwards one more time, that I was showing you 2 powers of attorney. I'm showing you here the Maryland statutory form, which has been out since 2010 approximately. And this is a simple power of attorney. There are 2 types. One is the simple version, which is called a limited power of attorney. We use that one, as do many estate planning attorneys. And we have a companion power of attorney that is much more flexible and much more broad, that we use in conjunction with the statutory form. Why do we do that? We do that so that the client has the full scope of powers that they may be looking for, because the statutory form itself is limited. There is a long form statutory form, but that form we find is a bit cumbersome because neither of those statutory forms can be amended or really changed much. So that is somewhat of a controversial issue, but we at Elville & Associates take the approach that the statutory form really shouldn't be amended very much, and that we use a companion or a dual set of powers of attorney. The statutory form, as I mentioned, is very simple. It is powerful in the sense that it is enforceable by law. So many of you may remember years and years ago, there were no such laws. So if a power of attorney was presented, let's say back in 2001 or 2002, well before the Maryland Power of Attorney Act in 2010, which brought this into law, the power of attorney could be rejected. Maybe the bank didn't like the way it looked. Maybe the bank didn't like when it was dated, that it was old. So powers of attorney could be rejected at a very critical time. So we don't want that. And the Maryland power of attorney is enforceable, and even enforceable with the penalty of attorney's fees. So that's a very, very strong thing for you and for your agents. But the statutory form does not cover everything. I'm not going to take you through all of these extra things that we believe should be covered in estate planning. Remember that powers of attorney are very, very personal to you. So one person might want a very conservative power of attorney that doesn't give the agents a lot of power, whereas another person would maybe take our advice and say, yes, my family situation is such that the flexibility that I have with this set of powers of attorney is so reassuring that my agents have tremendous powers. I trust them. I'm okay with that. But my point here is that powers of attorney, the powers are a counseling issue, and it's not just something that is a form that everybody signs. This is a form, and this is a series of counseling sessions that need to be discussed about how much flexibility, how much power do we give our agents. So here, as you look down through these materials and these bullet points, you can see these tremendous enhanced powers that you can include. powers to spend down for Medicaid, powers to create trusts, powers to fund trusts, powers to care for pets even, powers to receive compensation, just many, many things that it really enhance an estate plan, but it's not for everybody. This is a step-by-step process, and everyone has their own set of circumstances. Healthcare decision-making. Many people think this is the most important thing in estate planning. You may think so too. We strongly encourage you to really customize your advanced medical directive, no matter what kind of form you may use. The Attorney General's form is what we use. Why do we use that? Because it's widely accepted, it's widely understood in the Virginia, Maryland, Delaware area, the metro area. It's very easy to read. Now, other law firms, for example, will take these forms and make them very legal looking, actually make them somewhat difficult to read. We don't take that approach. We want you to customize your advance directive. And here I've given you some bullet points. You don't have to do this at all, but the Maryland Advance Directive is designed for this. It has lots of blank space. We encourage you to take it home and mark it up as a worksheet. We counsel you through these issues. The issue is how much flexibility, what are my personal preferences? Am I a religious person, and do I want to have some provisions inside of my advance directive that talk about that? All options are on the table when it comes to customizing the advance directive, because remember, if your agent, which is that person who's going to be your trusted person who's acting for you and advocating for you, do they really understand what your preferences are? Remember, unless you've expressed yourself in the advance directive, the only thing they know about your goals and values is what you've expressed during your lifetime. And many times these issues are hard to talk about. So the point of this is to say the advance directive names your agents. It talks about when your agent's power is effective. It talks about the HIPAA waiver, which gives your agents the ability to actually access your medical records despite the protections of HIPAA. It talks about the living will. It talks about whether you give your agents flexibility. And then it talks about organ donation and final arrangements. So very, very broad ideas, something that you need to take seriously. We recommend that you customize the advance directive, but it is not required. I'm going to go through one more slide, and then Jeff will stop and see if there's any questions. Some of you have heard of the MOLST form, the Medical Order for Life-Sustaining Treatment. It was a national initiative in 2013 that was actually called POLST, the Provider's Order for Life-Sustaining Treatment, or Physician's Order for Life-Sustaining Treatment. Maryland calls it MOLST. Maryland is one of only a handful of states that requires this form. Some of you on this call understand what this is because you live at a continuing care retirement community or an assisted living, or your parents may live at such a place where this is required, or you've been in a hospital or a facility where there's been a MOLST form provided for you. So in general, although there are many different rules about this, a MOLST form is required within 48 hours. What I want you to do, because that's outside the scope of this presentation today, I want you to look at this link for the Attorney General. There are videos and information about MOLST and healthcare decision-making in Maryland. I want you to learn about this if you're interested. MOLST is required in Maryland. If I went into that rehabilitation center, or I went into an assisted living in my example several minutes ago, I would have to have a MOLST form within 48 hours. That form is going to be filled out by a doctor or a nurse practitioner, as opposed to my advanced medical directive. So because this is a difficult topic to describe on this webinar in such a brief period of time, I'm simply going to say this. The considerations are really that you need to educate yourself. 2, you need to educate your agents, meaning your children or other loved ones, nieces and nephews, siblings, whoever's going to be your agent. And you need to make this decision. Will I go to my doctor or nurse practitioner and discuss MOLST with them? I've made my wishes clear in the advance directive, but this MOLST thing, what is it? It's a doctor's order, okay? And how does it relate to the advanced medical directive? So there are various differences. There is a worksheet that you'll see here that you could actually fill out. But the question really is, do you just educate yourself and let your agent deal with MOLST down the road, which many people do that. They just educate themselves and their family members and their agents and then say, now you will not be surprised by this. You're educated about it. You'll deal with it with my doctor. Other people want to be more proactive and they want to fill out a worksheet and attach it to their advanced medical directive and be more proactive about MOLST. So MOLST is an education piece. I know it's a complication that some of you have never heard of, and I apologize about that because many of us are quite happy with ourselves when we fill out the difficult advanced medical directive. But today we have to deal with not only that, but other healthcare decision-making policies in Maryland, and I would like to challenge you to educate yourself about the MOLST. Jeff and I will be glad to send you what we would call a MOLST package if you would like to see that, and we have no problem to send that out to you if you'll let us know about that so you can begin the education process. All right, Jeff, I'm going to take another stop and check my time.
Okay, Steve, we do have a question to get the ball rolling. And that question is, can you please define a remainderman?
Excellent question, thank you. So a remainderman, in the sense of what I was discussing this morning, is a person who receives the value, or what we call the real estate that is representing the life estate that the person retained, and the balance goes to the remainderman. So here's an example. I'm living in a property. I decide that I want to avoid probate, and I want to keep it very, very simple because there are limitations to life estate deeds. But I say, what I'm going to do is give my property from me to myself for life. So I transfer the property from myself to myself for life, with the remainder to my children. So in my example, I have 3 children. So those 3 children would be the remaindermen. So at my passing, my property automatically goes to the remaindermen. And so my children would own the property in 1/3 shares automatically with no probate at my death. So that's an example of a remainderman.
Okay, thank you. That's the
All
only
right.
question for now. Thank you.
All right. So moving forward, we're doing well on time. We've been going now for about 45 minutes to 50 minutes. Let's shift gears now and talk about estate planning as far as taxes. So we are now in a different environment than we were just a year ago. A year ago, we were in an environment of incredibly high exemption amounts. And when I'm talking about exemptions, I'm talking about 11.7 million per person federal estate tax exemption, meaning exemption from estate tax, and a $5 million exemption for Maryland from estate tax. Now let's talk about Maryland very briefly. Maryland is one of the only states in the country that has a state estate tax and an inheritance tax. We're not talking about the inheritance tax here, but let's talk about the 10% inheritance tax for just a moment. It doesn't apply, it's a death tax, but it does not apply to most beneficiaries. It does apply to people who are friends, non-lineal descendants, like nieces and nephews. If you were to leave a share of your estate to a niece, that niece in Maryland would be subject to 10% inheritance tax, but not children, grandchildren, and spouses. So just wanted to cover inheritance tax real quickly because that is a death tax. But Maryland has a $5 million exemption. Federal government gives us an 11.7 million exemption, or more than 23 million between spouses. So if we go down this bullet point to what is called portability, as you see that down the lower part, that is the ability, if you're married, for a surviving spouse to choose to utilize the exemption amount of the deceased spouse. So if a person dies and they're married and they have 11.7 million of exemption, the survivor, if they choose this, and this is called the portability election, they can choose that within 24 months. The government is being very, very liberal about this. For 24 months, they can choose to utilize that 11.7 million, plus they have the exemption amount that they currently own themselves at the time of their spouse's death, at the time of their death, and they can use both exemptions. So right now, we are in an environment that has changed or is possibly changing. Back in March, Senator Sanders proposed what was called the 98% Act. Excuse me, I may be misquoting that, Jeff. It might have been the 99.5% Act. I apologize. But Senator Sanders proposed this back in early March, and it was really an eye-opening proposal that was really taking a shot across the bow of saying the tax laws are now going to change dramatically. So Senator Sanders' proposal then ended up being another proposal by Senator Van Hollen, which is called the Van Hollen STEP Act, which really focused on the elimination of the step up in basis. So the cost basis adjustment that we've been used to now for many, many years, the government is seriously considering taking that away from us. So Senator Sanders' proposal, which was quite broad, we don't have time to get into that today, the Van Hollen proposal at the end of March, and then in April, President Biden rolled out his American Families Plan, which is still in Congress, it's still in committees, it's still being studied over the summer is my latest understanding. And this is probably a compilation of both of those prior bills where President Biden is going to roll out his tax plan. Now, we know income taxes are going to go up. We know that the top income tax rate is going to go from 37% to 39.6%. We basically know that. What we don't know is whether the estate tax exemptions are going to be reduced. Senator Sanders' proposal was to reduce the estate tax exemptions to $3.5 million per person from 11.7. So this has caused quite an uproar. But right now, we're not sure whether President Biden politically is going to go that direction of reducing the exemptions to 5.5 million or 3.5 million. They've actually come out and said that they're not really looking at that right now, but many of us think it's just temporary and that they will attack the basically taking away the step up in basis, which is a big income tax issue. They've already attacked retirement plans with the Secure Act and the acceleration of income tax on retirement plans. So it's just going to be a matter of probably the end of the summer or the fall to see whether the estate tax exemptions are going to come down. So many people are doing planning now in 2021 in advance of the lowering, let's say the potential lowering of these temporarily huge exemption amounts. In other words, utilizing those exemption amounts if wealth is, if a person of great wealth wants to use those exemption amounts while they're still available. We're doing a lot of that planning right now. And those that are less wealthy are basically just getting educated about the potential changes. One of the things that may happen if the exemption amounts are lowered is we anticipate the Maryland estate tax exemption might be lowered from, let's say, 5 million back down to 1 million, something along those lines. We don't know. Many of you on this call, even if you don't have a federally taxable estate, you might have a Maryland taxable estate, and that's an issue in and of itself. So we are in a new tax environment in progress. We don't know what exactly is going to happen, but for those of you, and this is a little bit beyond the fundamentals, but grantor trusts may be going away or be very limited. Corporate taxes are going to go up. Capital gains taxes are going to go up. The step up in basis may be eliminated. Janet Yellen said this is the #1 goal of the Biden administration. So this is not good news for those of you who are very concerned about taxes, but just know that right now we're in this process of waiting and seeing, and we will bring information to you on our website and in our newsletter and in specific letters that we will send out to our clients and advisors as we become more aware of what is actually going to happen and what is the what are the strategies that we can use. Marital control is one of the big issues today. Here's an example. Maryland has a new law now, and we're talking about marital control and remarriage protection as part of the idea of tax planning and the decreasing exemption amounts, but also about advanced planning concepts and estate planning. So in October of 2020, there was a new law called the New Spousal Elective Share Law in Maryland that really swings the pendulum from no protection of spouses of surviving spouses to lots of protection or extreme protections for surviving spouses. These laws have ramifications. They have ramifications for elder law. They have ramifications for protecting children from remarriage and the loss of assets to a new spouse. It calls into question whether or not we all should have prenuptial agreements if we remarry in the future. So all of these current environments, all of these things are happening, I should say, in the current environment where we are potentially looking at rising taxes, rising estate taxes with decreasing exemption amounts, and also new things to be aware of in Maryland planning, such as what we call the augmented estate, which is part of what I just mentioned, the elective share laws that protect spouses and the ramifications of that in planning. Now, I'm going to shift to long-term care here and asset protection in the last portion of the presentation. What is the difference? Now I'm shifting away from taxes and advanced estate planning to more of an elder care discussion or elder law discussion. What is the difference between elder law and estate planning? Well, the main difference is in estate planning, as you just heard, we're talking about processes, we're talking about how do we leave assets, are we concerned about protecting against remarriage, are we very concerned about estate taxes and inheritance taxes, and those things are also part of elder care planning, but the focus is more on disability, social security, housing, special needs, long-term care planning, assisted living, continuing care retirement communities. All of these things encompass elder care planning. So you see the focus is on disability planning, the focus is on how to pay for the costs of long-term care, the focus many times is just on hand-holding and counseling in more of a social work type of environment versus the straight logistics of estate planning. And sometimes these things meld together. It's not uncommon for me or for our attorneys to be sitting in a conventional estate planning conversation with an older couple where the conversation morphs into these kinds of issues that have to do with Medicaid. So we are concerned not only just about asset protection, so to speak, but asset preservation. It's not uncommon for us to meet with children or parents, and the question is, how can I preserve my assets from a Medicaid spend down? And of course, the issue of flexibility is huge. If we build flexibility into our planning, we can avoid the problems associated with guardianship, and therefore we have a chance to be able to preserve assets. If we don't have good powers of attorney and a good foundational plan, when a crisis comes, we do not have the flexibility to do what probably should be done, which is taking all necessary actions to preserve assets. Conversely, a person may say, I don't want to preserve assets. I just want to have good flexibility and I want all of my assets to be used for me. There's nothing wrong with that as well. But many people do want to preserve assets and have that flexibility. You'll notice the bullet point here about a divestment of assets for Medicaid purposes, basically, and for VA purposes. If we are going to if we are going to preserve assets, we have to be willing in some form to divest. So the idea here with planning, whether it's Medicaid planning, veterans benefit planning, is to use techniques that are optimal to be able to have flexibility, maintain control, and also have the maximum tax advantages. Right now, we've been enjoying some wonderful tax advantages for many, many years with the step up in basis, all of those things that we've come to enjoy. We're just going to have to see what we're going to be dealing with in the future. The good news, which I failed to mention on the prior slide, about the cost basis adjustment being taken away from us and all capital gain being due at certain points, whether that's at death or whatever the new laws may say. The good news is that what had been proposed is that if those laws go into effect, that there would be at least a $1 million exemption for a single person from capital gain, or a $2.5 million exemption for a couple. So that's the good news. And hopefully, if they take away the step up in basis, which is going to affect many, many people, hopefully it is only going to be focused on the super wealthy, meaning the average person will have this exemption or be able to enjoy some exemption. Jeff, I'm going to stop, I think, for the last time before we get into the final part, which is asset protection.
Thanks, Steve. I do have a couple questions. First one reads, should IRAs 457Bs have, quote, estate of X, insert the name, as a secondary beneficiary if X has a will and in case the designated primary beneficiary were to pass away?
Well, thank you for that question. So my response is, because I can't render legal advice about a situation like that, that unless we could meet person to persons for me to review the particular situation, generally speaking, we do not want to ever name an estate as a beneficiary of a retirement plan. And the reason for that is, and you may appreciate this illustration, Uncle Sam used to allow every person who received an IRA at our death. For example, if I pass away and I leave an inherited IRA to my beneficiary, the IRS would say, for example, Steve left his IRA to his child, so the child can stretch that out and have a lifetime payout of minimum distributions and defer the balance of the IRA over their lifetime. If the child doesn't want to take all the money, they can just stretch it out until their mid-80s. Well, unfortunately, with the Secure Act, the healthy child that I just talked about, my child, for example, now only has 10 years. They only have 10 years. This is not good news for clients. They only have 10 years and they have to take all the IRA out and pay all the tax within 10 years. Now, there are strategies to deal with this, and they're not wonderful, but at least there are some strategies that might make sense. But getting back to your point, we don't want to name an estate because an estate does not have a heartbeat. So an estate is a non-designated beneficiary, and a non-designated beneficiary does not even get 10 years. They only get 5 years. So let's think about that for a minute. If we make a beneficiary an estate, then we'd have to have a really good reason to do that, because if we make a beneficiary an estate, now what happens with most estates? The executor wants to get that estate closed. So even though it hits the default rule, which is a non-designated beneficiary, and you only get 5 years, the truth is that executor is probably going to cash out the IRA immediately and pay all the tax. So you don't even get to defer it for 5 years. Where I'm going with that is some beneficiaries are exempt from the Secure Act, like special needs beneficiaries, and they can stretch the payments out forever, just like it used to be available for all beneficiaries. But most beneficiaries today who are not special needs beneficiaries or one of the 3 or 4 other categories of exemptions, the vast majority of people are only going to get 10 years. So we don't want to name an estate because the practical effect is that IRA or 457 plan is going to be cashed out immediately and all the taxes paid. So we would hope in planning that we could structure it in some different way or find other beneficiaries other than an estate.
Very good, Steve. Thank you. Next question. The information you're sharing today, is some of it applicable to residents of the District of Columbia?
Excellent question. Thank you. And thank you for tuning in. Yes, much of it is applicable. The broad strokes of this information, I'd say 90% of it is applicable. The district does have different rules about probate and so forth, but many of the rules are similar. The district requires different things as far as notifying beneficiaries and publications of notice and so forth. But I would say the same concepts apply, subject to the fact that the District of Columbia has its own estate tax exemption. We do have a couple of lawyers here who are barred in DC and could get into more of the specifics about DC planning, but I would say yes, the vast majority of this information is applicable to the District of Columbia. And thank you again, and we are glad to answer your questions further about the district and planning.
Okay, next question. How can we best encourage seniors and their adult children to take action early while they are insurable to secure long-term care protection?
That is a wonderful question. You know, this is a difficult thing. I've experienced it myself in my own family, have had been touched by Alzheimer's disease and other things in my own, and long-term care planning in my own family. There's no good answer to this, except for me to say, I think, shooting from the hip here, that an elder law consultation is the best approach. And every circumstance is different. Every senior adult is different. There may be resistance. Maybe the person won't be willing to come in and listen to information. But if at least the children could get started with an elder law consultation to kind of establish, you know, what is the lay of the land, okay? What are these special needs concepts and Medicaid concepts and asset protection concepts, and how does a long-term care spend down work, and what does Medicaid consider as an available resource and a not available resource? What can we do to build flexibility? If we could get that conversation started, and that hopefully would include the senior adult, then I think we're getting on the right path. The most important thing about that conversation is not only getting that broad lay of the land and understanding intellectually what choices do we have and what do we do next. I would say equally important is getting the senior adults' estate planning documents completely updated so that the powers, subject to the person, the powers are as broad and flexible as possible, and that the agents and trustees understand what the powers are and how to achieve the person's goal or the family's goals. So I would say it's a straightforward answer, I know, but an elder law consultation with a focus on the lay of the land and total education about the choices available and how to anticipate the future, how to utilize a life care manager or a geriatric care manager for assessments and placement, but also getting the senior adults documents in place as soon as possible before they are suffering any kind of further decline. The last aspect of your question is how to get them to engage in long-term care protection. Well, I would say the answer there is going to be case specific, but the answer there may be, and I can't guarantee this, but the answer may be that we're sometimes having to talk to seniors in terms of loss. You know, what is your goal? Again, we're back to goals. Is your goal the protection of assets? Okay. Do you want to have a Medicaid spend down, but that might cause the loss of 40% of a retirement asset to taxes, because Maryland does not exempt retirement plans from Medicaid spend down. So sometimes I think in the minds of senior adults, it's a matter of what is their goal, what do they really want to happen, and what could happen if they don't protect themselves with long-term care when they actually have the assets to do it, and what is the actual cost of a Medicaid spend down. I think if we actually showed someone the actual cost, a Medicaid spend down is incredibly expensive. I think that is kind of the negative approach, but something that's necessary to illustrate the downside if they don't buy, or excuse me, if they don't implement some kind of hybrid policy, long-term care policy, or life insurance type long-term care protection.
Okay, very good. Next question. I think this is the last one for now. What is the step-up basis that has been referred to during the presentation?
Thank you for that. And I know some people on the call didn't really understand that, and that's a perfectly normal thing. Thank you for the question. Let's pretend that I bought my house for $100,000 years ago, and let's say now it's worth $500,000, and especially with today's market, hopefully. And let's say that I gave that house to my daughter today. I said to my daughter, whose name is Lucy, Lucy, I want you to have this house. Well, I sign it over to her. Well, under the current law, okay, I just kind of shot myself in the foot, or shot her in the foot, because she gets what is called a carryover basis. If my basis in the property is $100,000, but it's really worth $500, now if I've given it to her during my life and she eventually sells it, she is going to be subject to capital gain when she sells it on the difference between 100 and 500. So my daughter, in essence, would pay capital gain on $400,000. If under the current law, I were to pass away and then give it to my daughter at the time of my death, now she would pay no capital gain because she receives it at a stepped up basis of 500. My basis was 100, but the cost basis or stepped up basis is now 500 at death. So if she sells it, she pays no capital gain. That is what the Biden administration is proposing, along with several senators, to take away, is the cost basis adjustment at death, so that at my death, instead, I might be subject to the capital gain at the time of my death, and there's no exception. What we're hoping for is that there's going to be at least $1 million exemption from that capital gain, or $2.5 million per couple, but we're going to have to wait and see.
Okay, and one more, Steve, for now. Does the Maryland inheritance tax apply to out-of-state beneficiaries?
That is an excellent question. The answer is if the decedent lives in Maryland and it's a Maryland administration, then it would. If the decedent has changed states to another state and they've actually changed residency, then the Maryland estate tax would not apply. Excuse me, inheritance tax would not apply. But in that example, if I understood your question, Maryland inheritance tax would apply because it was a Maryland estate or trust.
Okay, that's it for now. Thank you.
All right, thank you. And I know we are now down to our last 15 minutes or so, and thank you for your questions, which helped the presentation tremendously. I'm going to wrap up the conversation with asset protection. We've talked about the fundamentals of estate planning, wills versus trusts, the nuances of incapacity planning. We've talked a little bit about estate tax and so forth. We've talked about Maryland law changes recently, a few changes like the augmented augmented estate or elective share. Now I want to wrap up with something that we find very valuable to clients, is an understanding of asset protection. Now, asset protection may not be something you walk around thinking about every day, but when you are dealing with your financial advisor or CPA or estate planning attorney, and by the way, we hope you have a planning team. We want to help you facilitate that if you don't have one. This is going to be a topic of conversation, because we're living in a very litigious society, and we want to avail ourselves of all the asset protection we can get. So I like to break it down into 3 categories. Lifetime asset protection you may or may not know you already have, to have an understanding of that. Long-term care asset protection, we spent a little bit of time just talking about that a minute ago. And then asset protection at death. So lifetime asset protection, this is not something that is usually at the forefront of elder care planning or special needs planning, but in general estate planning, we need to understand this. Tenants by the entirety. So I'm sorry to focus here on married people. If there are unmarried people on this call, tenants by the entirety is a marital form of ownership. What it basically means is, and a typical example is the marital home or your residence. That home is owned as husband and wife or spouses, however we want to characterize that, and it is an undividable whole. If this spouse gets sued and this spouse doesn't, the creditor cannot undo the whole. So the house is protected if only one of the parties is sued. Now, tenants by the entireties fails if both parties are successfully sued, and there are strategies for dealing with that. But basically, if we can get tenants by entireties protection for spouses, we want to get that. Now, the good news in Maryland is, and Delaware, if we are tenants by the entireties on any form of ownership, for example, you can be tenant by the entirety on a joint brokerage account. Basically, any account in Maryland except an IRA, you should be able to be own it, I should say, as tenants by the entireties. If you then have a revocable trust and you transfer that property into the trust, a Maryland law now says that property continues to be protected as tenants by the entireties. You do not lose that by transferring that into a trust. So we want to get as much property as we can titled as tenants by the entireties for married couples. Life insurance, if you have a child and name your child as the beneficiary, that is protected from creditors. If you have a spouse and you name your spouse as beneficiary, the life insurance is protected from creditors, both the cash value and the proceeds of the life insurance. Annuities are protected, same way. Qualified plans like the person who just talked a moment ago, 457 plans, 403s, 401ks, IRAs are protected from the claims of creditors. However, we just talked a few minutes ago about the beneficiary designations and inherited IRAs. Those are not protected from the claims of creditors as per the Supreme Court about 12 years ago or so. So we have to use trusts for children and grandchildren and nieces and nephews and others if we want to protect inherited IRAs, because otherwise they will not be protected from bad spouses, creditors, and so forth. Now remember, a surviving spouse will usually take one of two things, either an inherited IRA or a rollover IRA. And most of the time that's going to be a rollover IRA, and he or she will have asset protection in that rolled over IRA. Domestic asset protection trusts, this is a very brief topic on this particular call today. Delaware, Nevada, Alaska, South Dakota, Wyoming, and about 16 or 17 states have domestic asset protection laws where we can self-settle a trust in that state, and it's protected from the claims of creditors in various ways. So we don't have time to talk about that today. Maryland is not an asset protection state in that sense, but Maryland has excellent asset protection in other ways, which we will talk about here in just a moment. So the first concept, lifetime asset protection. Now, asset protection in the long-term care context. This is really the heart of elder law, although elder law encompasses many other things. Many times we use what is called a Medicaid asset protection trust, which is a very powerful tool. Let's say that a person wants to put an asset out of reach of a Medicaid spend down, whether it's a single person or a married couple. They can use this tool, and it's flexible. It allows the grantor to have control. It is a divestment of assets, and it works in various ways to give the person flexibility and power over the ability to get ahead, way ahead of a Medicaid spend down situation. And when I say way ahead, I mean 60 months, 5 years in advance of a Medicaid spend down or a crisis. Veterans asset protection trusts are also a powerful tool. In 2018, the Veterans Administration changed its rules and implemented a look back period, just like many of you have heard about Medicaid having a look back period. But this is in some ways a bad thing, but in many ways, veterans planning became more favorable. So it's complex, the divergence or convergence of Medicaid planning and veterans protection planning, but that's something that we work out in our elder law discussions. Uses of wills established to establish trusts for a disabled person. So in other words, let's say we have a disabled spouse or a person who is slowly, with a progressive illness, becoming disabled, heaven forbid. Now we have the ability to, and we always have had this ability since 1993, but to use trusts established under wills for asset preservation. If we transfer assets to one spouse, who is the well spouse, God forbid that well spouse were to die first, that well spouse can leave assets in a further trust that is protected from a nursing home spend down. So that's a very powerful tool that we utilize quite a bit. You heard me mention the augmented estate. Now, what does that have to do with elder law? And remember, the augmented estate is part of the discussion of the elective share laws back in October of 2020. Well, to make a long story short, there was an exception made for elder law planning or elder care planning that basically said this: if we use a trust established under a will, like you see here in this bullet point, and that trust is established for the disabled spouse and the well spouse dies first, the amount of money that the disabled spouse would routinely be entitled to. Let me say that again. The amount of the assets that the disabled spouse is protected by law to have, which is at least 1/3. That 1/3 can be put into this special needs trust established under the person's will, and there's been a compromise with the lawmakers that that will be protected. Now, of course, what happens is most spouses leave 100% to their ill spouse if they were to die first, and they leave it in that trust. But my point here is that Maryland will have no recovery against the estate of the surviving disabled spouse. And that is a very huge planning tool that we can now use in Maryland very successfully. We always used this rule, but it was never codified until recently. So remember, crisis planning is, I've got a crisis right now, what can I do? Well, we can usually, subject to taxes, we can usually save under the current law about 50% of the assets, even if there's been no planning in advance, as long as we have the flexibility and the powers of attorney. But the 5-year look back period, which is what most people would look to do, is get ahead of the 5 years by using Medicaid asset protection trusts or veterans trusts. But just know if we can't get past that 5 years because we've waited too late to plan, we can always use the rule of halves, which means we can roughly save about 50% of the assets if the laws stay the same. Life estate deeds, we talked about that earlier, about what is a remainderman, what is not a remainderman. This simply is a form of life estate deed that says, I am reserving a life estate, I'm giving the balance of the estate immediately to my child because I'm giving up the right to sell it. So this is similar to a tool of just giving away the asset and starting the 5 years. There's nothing wrong with this strategy. It just doesn't have a lot of flexibility. So you have to be very careful when we use these strategies. And we have to decide whether we're going to use Medicaid trusts or a simple life estate deed. And lastly, I want to talk to you about asset protection at death. We've talked about asset protection during life, asset protection for long-term care purposes. Now, what kind of asset protection can we do for our children, grandchildren, spouses? This can be done in an elder care plan. It can be done in a non-elder care plan. Basically, we are just leaving trusts for spouses. If we want to protect against remarriage, we might call that a marital trust. There are various ways of doing this. These are spendthrift protected trusts, as you see here in one of these bullet points. That simply means that the spouse or the child or the niece or nephew, whoever the beneficiary is, they cannot alienate or assign their interest to a creditor. And because they can't do that, they can't negotiate their trust to a creditor. That trust has integrity and will not be subject to the claims of creditors as long as we haven't given them a general power of appointment. So what we want to do in a spendthrift trust, again, we're not saying the beneficiaries are spendthrifts, although they may be, we are giving them spendthrift protection. Now, the beneficiary might be their own trustee, maybe not. In Maryland, a beneficiary can be their own trustee, but it's better if they're not. Some people want their child to be their own trustee. Other people understand that it's probably not the best protection to have them serving, so we would put an independent trustee in place. And maybe that's a corporate trustee, maybe that's an individual trustee. But my point is that's a discussion that has to be had. If we are using spendthrift trusts, which usually are long-term, Maryland says trusts can last forever. Forever is a long time. So we would probably want to use a tool called a trust protector, which is a special fiduciary that has the power to give flexibility to the trust, the power to give flexibility to the beneficiary over a long period of time, but actually make sure that your intention or the grantor's intentions are carried out over the period of the trust. So these are very broad topics about protecting assets. We've talked about protecting during life. What do you have just as general tools during your life? What can you use for long-term care for asset protection? What are the strategies? And just giving you a little bit of what can be discussed there. And these asset protection strategies at death are pretty easy to implement. You just have to have an understanding, a clear idea of what your goal is, why you're protecting and what you're trying to protect against, and understanding the power of the planning and the limitations of the asset protection planning. And then lastly, we do a lot of special needs planning for special needs and disabled persons at the death of parents, grandparents, siblings, and huge area of our practice, hugely important area where so much education is needed. Parents are just, and grandparents, just incredible people taking care of their disabled loved ones. We are very privileged to be doing a lot of special needs planning in the special needs community. So Jeff, as I wrap up, I'm just going to say a few words about the Secure Act. We mentioned it very briefly. This was signed into law by President Trump in 2019. At the end of the year, it became effective in January of 2020. It ends the ability to stretch the IRA unless there are exceptions. So there are three categories now of beneficiaries. The non-designated beneficiary, which we mentioned earlier, like an estate, we don't want that. There'd have to be a very, very good reason to have an estate as a beneficiary. The designated beneficiary, which used to be what we wanted, but now it's what we're stuck with, which is the 10-year rule for healthy beneficiaries, basically. And then there is the eligible designated beneficiary, which is the exception. And there are about 5 categories of eligible designated beneficiaries: spouses, minor children, siblings that are not more than 10 years younger. That's a very different one. Special needs beneficiaries and their trusts, and chronically ill beneficiaries and their trusts. So this is something that there are some planning strategies to try to deal with the acceleration of taxation unless the beneficiaries are exempt, which we also need to be taking that in consideration. So as we end, and I thank you for your patience, I think we're right at the time to end. We invite you to set a time to consult with us. We want to give you space. I'm here in our main conference room in Columbia. There's lots of room here, lots of time to think, lots of space to relax. We want you to complete a questionnaire. This is work, and we want you to participate in the process. Some of this information that you give us is the most important thing in estate planning, this accurate upfront information in an estate planning questionnaire. Again, we want you to relax and know there's nothing to fear. We want you to bring your current documents. We don't charge to review your documents. We want you to have an advisory team, which would include your CPA and financial advisor. It might actually include a life care manager if there's an elder care type situation. We want you to come in with questions like you've done today. We appreciate that very much. And again, our goal here is to educate, give you time to think, space to think, and facilitate a discussion and peace of mind. So Jeff, I'm going to turn it over to you. Thank you for being a great moderator today. We'll see if there are any final questions, and we'll let people get on with their day.
All right, Steve. Well, thank you very much, as always, for a great comprehensive presentation. And I think we do have one more question as of now. So with that being said, now is your time to get those last questions in, as we are at 11:30. So the final question for now is, does the personal representative have to be local or a Maryland resident?
Wonderful question. The answer is no. The personal representative can be out of state, but that personal representative does have to have what is called a resident agent in Maryland. And typically that might be an attorney that has been engaged to try to assist, or a CPA, someone who is in Maryland, and that person is going to be the designated resident agent. But the executor or personal representative can be out of state for sure.
Okay, very good, thank you. Checking for any last questions. Doesn't look like we have any. So I'll just say a couple things real briefly, since we are at 11:33, it looks like. Again, thank you, Steve. Thank you all for your questions. We always appreciate them. I will be sending out a post-webinar follow-up email, as I always do. I'll be sending the video for today along with the MOLST packet that Steve alluded to. It's a wealth of information, so that's something that I'll be sending out. As far as our webinar series, we are going to be taking a break for a couple of weeks. We are going to be coming back in full force for the end of July with many new topics. They include pet power, estate planning for your pets. Did you know that you can plan for your pets? And we have many pets that are dear to our families, and so you want to take care of them. So you're going to learn all about that from Steve. Understanding Alzheimer's and dementia. A presentation from the National Multiple Sclerosis Society. We have a new advisors forum for our advisors on July 21st, and more. We have other topics that we're going to be bringing back as well. So please consider us a resource here, as Steve said. Whether you're new to estate planning or you have documents that need to be updated, there's a lot of changes in the law, as Steve alluded to. We're here as a resource to you. We don't charge for initial consultations or to review documents, as Steve said. So lastly, please take a couple minutes to fill out the post-webinar feedback email that you're going to be receiving. We value your comments and we read every one, I can assure you. So let me check to see if there's any final questions. And it doesn't look like there are any. So with that being said, we appreciate your support of the Elville webinar series and your relationship with Elville and Associates, and hope you have a wonderful day. So thank you very much.
Thank you, everyone.